Hello and welcome to this latest Smithstone Waters webinar. Today we will be reviewing the government's new skilled worker system that's due to come into force on the 1st of December. I'm delighted to be joined by Alastair Mason, one of our senior account managers who's been working with many of our clients in getting them prepared for the new system. So Alastair, what would you say are the main differences between the current Tier 2 system and what employers are going to expect under skilled worker?
Right, well, there's quite a few. So I would start with the lack of advertising. So under the old Tier 2 general system, the vast majority of roles, you had to advertise the role to the UK resident labour market first. It took 28 days, it was a pain, you had to jump through lots of hoops, save lots of documentation to prove that you had carried out the test correctly. You no longer have to do that. So they've removed the advertising requirement. So immediately you're cutting 28 days off the lead time to get most skilled worker visas. So huge benefit. And sort of connected to that really is the removal of the monthly quota process. So under Tier 2 General, we had a monthly quota for restricted certificates. The 5th of every month, everybody in the office here would be applying fervently to the Home Office to get those certificates. By that point, the advertising had to have completed. You had to have the details of the job that you were planning to sponsor, and then you went into the monthly quota and asked for a certificate. Now, the quota was only really oversubscribed for a few months, a few years back, but it was a pain to do this because there was a deadline of the 5th of each month, and it took the Home Office a week, sometimes more, to get back to you with their decision. So it dragged the process out. I mean, if your advert's only closed on the 6th, then you'd have to wait till the following month, the following 5th, to meet the quota. So the removal of this quota, it not only opens up the skilled worker category to many more applicants, but I think practically for our clients, it reduces the lead time again to get a visa. So a great benefit. Getting onto some more technical aspects of the visa category, they've also changed the minimum salary. So the absolute minimum is dropping by almost £10,000 from the 30,000 that it was under Tier 2 General. Of course, you'll have to pay attention to the role that you're performing because that may impact your salary. But by and large, the minimum salary is falling. Another big change, I would say, if not the biggest change, arguably, is the skill level falling again. So under Tier 2 General, we had, 12 years of jobs only being able to be sponsored if they were at level 6, RQF level 6. So what that meant was that the job that the person was coming to fill in the UK had to be at degree level or higher. The person didn't have to have a degree per se, but the role they're coming to fill had to be at degree level. That meant that many of our clients only had a limited number of roles that they could sponsor in. The new system is dropping the skill level to level 3, which is A level or high school level, and it therefore opens up a huge number of roles that can now be sponsored. There are changes to the cooling off period as well. So cooling off is being removed for Tier 2 General, now the skilled worker category. It applied under Tier 2 General, and it was a pain, to be honest. It meant that on the rare occasion you did identify someone that had held a Tier 2 General visa within the last 12 months, it might prevent you from sponsoring them. There were lots of exceptions to that, such as extensions, changes of employment, but there were occasions where clients came to us and they weren't able to sponsor somebody because of this reason. Cooling off is now gone for skilled worker, and that is a huge benefit to clients and individuals alike.
Okay, thanks Alastair. So although the structure of the system hasn't changed too much, there are some significant differences there, especially with regard to, as you say, the level of the role, and of course the removal of the resident labour market test.
Yes.
Some say that the new system isn't so much new, but rather a rehashed version of our Tier 2 system. Of course, we have sponsors and we have points awarded for attributes under skilled worker. What are the differences that employers can expect by way of how points will be awarded?
So let's start with the total number of points that you need to qualify. So you need 70 points to qualify for a skilled worker visa, and there are 50 mandatory points. So 50 points that you can't get away not having. You have to have those points to qualify. Number one, you need a sponsor. So an organisation in the UK that is willing to sponsor you. They have a sponsor licence. You also need a job that is at level 3, RQF, level 3 or higher. So as we talked about previously, that opens up a whole new raft of jobs that can be sponsored, but they still need to be at level 3. And how we assess that is we align the role to a code, a SOC code, and the codes are given a level. So if you're aligned to code 2136, for example, software developers, you would be at level 6, you could be sponsored. Okay. Now, the final point of the mandatory criteria is English language. So you have to be able to demonstrate your English language. And you do that by one of 3 means. You can use a degree, you can take a test, or if you have a passport from an English-speaking country, you can use that. And those English-speaking countries are the usual suspects really, Canada, Australia, the States, etc. For degrees, UK degree, fine, nothing else required. If it's an overseas degree that was taught in English, we see lots of these from the US, from India, from Australia, then you need to get your degree verified. It's verified by an independent body called UK NARIC, and they will confirm that it is acceptable for English language evidence. So those are the mandatory criteria. So there is English language, job from a licensed sponsor, and a job at level 3 skill level or higher. You then have to score a further 20 points to get your total 70. And those 20 points can come from a variety of means. So if we divide it into 2 sides, one is salary, one is skill set. So on the skill set side, if you have a PhD level role that you're coming to fill, then you get extra points. If you're coming to fulfill a job in a PhD level role in a STEM subject, then you get extra points. If you are fulfilling a role in the shortage occupation list, so there is a list of a couple of dozen roles in the UK that are considered in shortage, software developers is one, then you will again get additional points, 20 points. Finally, based on your age or where you're coming from, i.e. being a student, you can again get an additional 20 points. It's what's been called switching or applying as a new entrant. So you're applying when you're under the age of 26, or you're coming or have previously been in one of the student categories in the UK. You can score those additional 20 points. So there are 4 means in terms of background or skill set that allow you the 20 points that you need or contribute towards those 20 points that you need. PhD in STEM subjects, new entrant rate, or shortage. If you don't qualify under those means, then you need to look towards salary. And there are salary bandings that allow you to also accrue the additional 20 points. They vary depending on the role that you're performing, but there is an absolute minimum that you must meet regardless. Okay. So that's how you get those 20 points, either your skill set, your background, or your salary. But regardless, you need 20 by mixing and matching those elements.
Okay, well, thank you. It's really clear. I mean, could you sort of walk us through an actual scenario of what that might look like for an employer?
Sure. Okay, so I could give two examples, one very straightforward and one that might throw up some issues for an employer. So let's start with I'll use the example software developer again because we see it so often. So software developer offered a role in the UK, their sponsor is a licensed company, and they've previously studied at a UK university. So they studied here, they've gone home, they're now applying for their first job in the UK. So firstly, they've got a job offer from a licensed sponsor, they have a job at level 3 or higher, and they have a UK degree, therefore meeting English language. Okay. They get the 50 points straight away. Moving on to the tradable criteria, I wouldn't even look to salary or PhD, etc. I would straight away look at the shortage occupation list. Software development is there, therefore they get 20 points for being on the shortage list. You do not need to be concerned with assessing any other element of those criteria. They get the 20 points, move on. Maybe a more troublesome scenario, let's say a company want to sponsor a role in their finance department. Let's say the salary is £23,000 per year. The person is moving from India and they have a overseas degree that was taught in English. So, job offer from a licensed sponsor, fine. Skill level, you'd need to look at the role in detail and make sure that it's above level 3, but it's very possible that it is because so many roles now are. And English language, they won't meet it automatically from their degree because it's not from within the UK. They'll need to get that degree verified by UK NARIC. Costs about £150, takes a bit of time, but lots of degrees still can be used. They then need to get some extra points, the extra 20 tradable points from those criteria that we talked about. Most finance roles are not going to be on the shortage list. So we need to then look at, is this applicant applying from the new entrant side of things? So are they under the age of 26? They've not been in the UK before, so they're not switching from a student visa. Are they under the age of 26? Sure, yeah. If they are, 20 points automatically. If they're not, and they don't have a PhD, then we're stuck with salary. And keeping that £23,000 salary in mind, that's where sponsors might face some difficulties. They've got a role that maybe isn't in shortage, they're not employing someone under the age of 26, the individual is not coming from a PhD background or into a PhD role rather, then your only reliance is salary to meet the criteria. And with salaries of this level, that's where they may come unstuck.
Okay, perfect. So that's really clear, and it's always great to look at a scenario-based situation. I'm sure employers will relate to that. So Alastair, I have a question actually that was sent in from one of our managers in our Hong Kong team. So I'll just read this to you. She said that over the years we've seen the government position on switching categories change considerably. I mean, prior to current PBS, switching was quite normal, and there was even a time when visitors could switch into work permit approval. But over recent years, this has very much gone the other way. How does the new system deal with that?
Well, it's not a complete return to times of old, but it's getting there. So you can now switch into a lot more categories than you previously could. But before I move on to the exact categories, maybe it's best just to explain what switching is, because it's not always clear what is switching. So firstly, switching is moving from one visa category inside the UK to another without having to leave the UK. Mm-hmm. Now, as you said, James, over the years, what the Home Office have done is they've forced people to leave the UK to make applications on occasion. And for clients and applicants alike, it's a huge pain. So we would see sponsors or employers in the UK without their worker because they've had to return home to Australia to switch category for anything up to 6 weeks. You have the time element, but you also have the cost element. So we frequently see employers paying for the costs for that person to return home, where they may no longer have a home. So they may have to rent a property, they may have to pay for flights, the costs rack up. So switching in country is hugely important for individual and for employer alike. And what the new system has done is open up a whole raft of opportunities to do that. So in short, you can now switch from any category to any category with some minor limitations. There are a small number of categories you can't switch from, namely visitor visa. That's quite common around the world, that being unable to switch from that into a work-based category, and you still can't. We weren't expecting that to change. And there are some other more minor categories that we come across less often, in corporate immigration at least, that you cannot switch from. So examples would be domestic worker or people outside the immigration rules. So there are some categories you can't switch from, but the rest of the immigration system you can switch from to a work-based category. Huge benefit. And to give some examples, I mean, over the years I've had numerous people who've been on dependent visas or Tier 5 youth mobility visas. And previously I would be having discussions with their employer saying, well, we need to time their application because they're going to have to apply from Australia, China, wherever. And now that's not an issue. Now I can say, look, carry on working inside the UK, we'll switch your visa and you'll switch into the skilled worker category seamlessly, effectively.
So there's some fantastic benefits there, both for the employer and the employee.
Yeah, definitely. For the employer, cost and time are obviously huge impacts. For the employee, not having to travel across the globe to get a visa is one, but also sometimes when you do have to do that, you're leaving behind your family in the UK to go and get your new visa, and obviously that's not going to be the case anymore. It should be a relatively seamless transition from within the UK, from current category to skilled worker.
Government application fees have been very much an issue for debate over many years now because they've gone increasingly high. And the government made no excuse that was anything other than a deliberate policy as part of their immigration control. So really interested to hear, Alastair, what application fees look like under the new skilled worker system, and not just your standard visa application fees. What are the additional fees that employers and employees alike will now have to pay?
Fees are quite frankly astronomical now. For a single applicant on a 5-year visa, skilled worker visa, you could be looking at fees in excess of £10,000 all in. For a family of 4, that jumps up to about close to £30,000. Astronomical. So where do I start? So everybody is going to have set fees that they will have to pay, but there are some factors that will change the level of fee that you pay. So let's start with the visa fee. Most people will pay between £600 and £700 for a 3-year visa. It doubles if you go up to 5 years. But there are some allowances there for certain categories of individual. So people under shortage, NHS workers, people who are under the ICT graduate trainee route, they will pay lower visa fees. Slightly, but lower still. The big fee that we see today is the immigration skills charge. That's the biggie. So it varies depending on the size of the company, and size of a company under the Home Office regulations anyway is denoted by the Companies Act. So based upon turnover or number of employees. Smaller companies will pay a lower skills charge of £364 per year of visa, paid all up front. And larger companies will pay £1,000 per year of visa, again paid all up front. So for a 5-year visa, for a large company, you're looking at £5,000 just for the skills charge. Now, some of these fees you can get back if the individual leaves your employment, but it's not always reliable. As we've learned over the years from the Home Office, their refund system isn't terribly reliable. And they're not always refunded. You're not guaranteed of a refund. It depends on the circumstances of that person's departure. Sure. Now, there are some of the minor fees that surround the application process that the employer also has to pay, which includes the certificate fee. So the certificate fee is what links the individual to the sponsor license, and you pay £199 for that certificate. Now, out of the fees we've just talked about, the certificate and the immigration skills charge are 2 fees that the employer must pay legally. They cannot pass on that cost to the individual. Mm-hmm. The visa fee, however, can be passed on. And finally, we get to the NHS fee, so the immigration health surcharge. It started off at £200 per year of visa. It went up to £400 per year of visa, and it's just gone up to £624 per year of visa. So again, 5-year visa is nearly £3,000 just for a single applicant. If you've got a family of 4, fees are going to be significant. There's a small allowance that happened in the recent changes, which is that dependents under the age of 18 pay at half the rate. So there is a bit of leeway there, but it's a drop in the ocean really when you consider the total fees that people are having to pay. And that fee, along with the visa fee, are fees that can be paid by the individual directly, not by their employer. Okay. Although many employers will cover it, of course. Now, those are the basic fees that nearly everybody is going to expect to pay. But as I said, there are some exemptions. So we've talked about NHS workers, people in PhD level roles, people in the ICT trainee, graduate trainee category. They will have relaxed fee regimes. So some fees may not apply, others may be lower, etc. But there are other fees that arise as really ancillaries to these that you can't get away from paying, unfortunately. So starting with English language, you may have to pay to get your degree verified if it was taught overseas. You may have to pay to take a test, and that's frequently over £100. You may have to go and get criminal record checks done if you're coming to work in certain public sector jobs,
Okay, yeah.
and they can cost money as well. There are lots of other optional ancillaries when you submit your application, and they go from getting text message updates to having a courier return your passport from the visa centre. And all of these things add on additional costs. Finally, inside the UK, one cost that we're seeing, which is all too common nowadays, annoyingly, is the fee from Soprasteria to attend a biometric appointment. There are free appointments at certain centres around the UK, the main hub centres, so there's one in Croydon, there's one in Birmingham, Cardiff, etc. But getting a free appointment is extremely difficult, and if you want an appointment at a convenient time of the day, or perhaps at the weekend, or in the very near future, then you're going to pay an additional fee for that. Mm-hmm. And those fees can run to £250, £260 for an appointment per person. So again, family of four, extra £1,000 to go and give your fingerprints. So that's the situation of the fees at the moment. We saw the Nhs Fee increase recently. We haven't seen any increases as a result of the skilled worker category being introduced yet, but the Home Office may yet surprise us with something. We're waiting to hear from them on that.
Wow, so there's some really expensive considerations for employees and employers there. And I think really important for employers as they think about the next year or so to take these additional fees and expensive fees into account when they're looking at budgets and the relocation of their workforce. Alastair, any major change to immigration legislation like this always has a huge impact on recruitment and employers' recruitment operations. What would you say are the main changes that recruiters now have to bear in mind for the skilled worker regime?
Well, firstly, it's got to be lead times to get visas. It's a good thing. Lead times are falling. So we had the old 3-month period that we would advise our clients to say, look, if you want to get someone in under Tier 2 General, ideally give us 3 months, because the role might have to be advertised, we've got to get the monthly quota in, and then we've got to get the visa itself. Sure. I can see that falling now to 6 weeks maybe. So visa processing times across the globe usually max out around 20 working days, but there's often means to expedite. I mean, in New York, during normal times, you can get a visa in as quick as 2 working days. So without the advertising, without the monthly quota, we could have a far quicker turnaround of visas, which is of great benefit. On the flip side, cost. We talked about it a few minutes ago. Costs are unescapable, they're huge. And I think what's more of an issue potentially now for sponsors is that if you can sponsor all manner of roles and you can sponsor people at lower skill levels, lower salary levels, but the visa is going to cost £10,000, then you have a question as to whether you're going to spend that level of money. And this comes really down to internal policy and deciding on, will you decide to sponsor everybody and anybody you can, because you can now sponsor a huge number of people, or will you only sponsor key roles because of the cost implications? And
again, that's deliberate policy by the government to ensure employees go through that process.
Yeah, absolutely. So I think those are the two biggest considerations. Other more minor things that would come to mind for recruitment teams would include this whole thing surrounding European workers. This is a whole other topic in itself, but we've obviously got two groups of European nationals, people who have lived in the UK or will be living in the UK by the end of the transitional period at the end of the year, who fall into one group, and then people who arrive in the new year and thereafter who fall into a second group. So as a recruiter in the past, you would simply see someone's passport and then it's either visa, no visa, start work, or wait until you get your visa. Now, I think the question is going to be, well, you're from this country, potentially you need a visa, or you're from Europe, And then you have to ask the question, well, when did you arrive? Do you have a
Sure.
And it's a whole other raft of questions that recruitment teams will have to ask. It's anything but simple. And then finally, I already mentioned it, but really this opening up of roles for sponsorship. So roles will open up, and it won't be as simple as it was to decide whether someone can be sponsored. Previously, you were very clearly either highly skilled and paid the correct salary or not, and that was it. And to give an example of a law firm, that meant that for the majority, only really fee earners, lawyers, could earn, or could obtain rather, their Tier 2 visa. Now, you're opening up a whole other area of roles for sponsorship. All of the support roles, finance, IT, HR, etc., could now potentially be sponsored. But you have to take into account salary considerations and will they meet the requirements of the category. It's not as black and white as it once was, perhaps. It's a good thing for sponsors who have been desperately trying to sponsor lower skilled roles. It's also a headache. The Home Office have given this opportunity with one hand and they've really created a headache with the other because you've got this whole potential area of new sponsors and new sponsored roles.
Sure. So there's some great benefits in so much as the speed of the recruitment process for an overseas worker. But there are still lots of areas that recruiters really have to concentrate on and ensure that, you know, they are going down the right path, especially with regard to, you know, this immediate change of legislation and the end of transition as well. Those two things combined can cause some confusion.
I think so. For me, it's less of a technical issue in terms of getting the visa itself. The greater issue is internal policy, deciding who you will sponsor and the cost implications that go with that. That's really, I think, the take-home message for recruitment teams is get your policies in line now, because in the new year, your costs could be astronomical if you do decide to sponsor everybody you possibly can. Okay.
Yeah, very good advice. Thank you. Finally, Alastair, what are the key things and the real take-homes for employers to think about under the skilled worker programme?
Okay. Firstly, I would urge employers to realise that this is not a massively new, scary system. This is the old system with a lick of paint. Despite what the government trying to sell it to us as, I do not feel it is a huge departure from the old system. The concept of sponsorship, salary requirements and skill requirements, English language is still there. There are some great benefits that almost seem too good to be true in some ways, like the removal of advertising. But sponsors need to be aware of their duties to keep historical documentation on file for previously sponsored roles as well. So don't ignore your historic requirements to keep those documents. My take-home message will be to get your house in order now, because I think in the new year, as we've modelled, we see that some sponsors will be increasing visa numbers by 20 to 30% because of the need to sponsor European workers. And as we talked about with the cost implications of that, they can have huge ramifications for a business. So the technical aspects are one thing to consider, but with our advice and with what's a relatively unchanged qualification system for visas, that's of less concern. What is of more concern is who will you sponsor? Will you provide support for their dependents? Will you cover all of the fees? Or will you only contribute to the fees that you're obliged to do, so i.e. the skills charge and the cost fee? So those are the things that I would really consider as being important for an employer today, is planning and getting things set as to how your policies will work come the new year.
Well, thank you, Alastair. That was some fantastic information and a real in-depth look at the skilled worker category and really unpicking some of the detail there. So that's really appreciated, and we really hope that you found that very useful. Thank you.
That concludes today's webinar. Thank you for watching, and should you require any further information, please find our website on screen now. For all our webinars, please follow Smithstone Waters on social media and subscribe on YouTube or Vimeo.